In this next video, we're going to talk about an accommodation process over at Target that sounded like it started off pretty good, but seems like it might have gone down a completely bad path by the end of it. I asked Human Resources for reasonable accommodation via email, and they provided me with an ADA form via email. I got the form filled out by my doctor, and I returned it to Human Resources in person. Upon returning the form, HR stated, "I can tell you right now, they will deny it. I'll give you another form for your doctor to complete, but I'll still give it to your business partner that handle these requests." They denied my request and told me to work it out with my OM. I made another request via email after the first denial. I was then called into the office and told that they only had 5 minutes to talk. She denied my request and told me to come back if I thought of anything else. I know they don't have to provide you with the request you asked for, but legally they are required to provide you with some accommodation that is effective. I was at least expecting, we can't do this, but this is what we can do for you. I get nothing. The accommodation I requested is already something provided to non-disabled TMs, so I'm not sure what the issue is. My name is Alex Castro. I'm a labor and employment attorney with AXC Legal based out of South Florida. Everything that we're going to talk about today is not legal advice. If this story sounds familiar to you, or if it sounds like an issue that you're dealing with, make sure you consult with a qualified employment attorney to discuss your situation. So what really stands out to me about this story is that it sounds like the process started decently, and then for some reason, just turned into a total crapshoot. One of the most important parts of the ADA accommodation process is exactly that, the process. And in legal terms, we call that the interactive process. The interactive process is just legal mumbo jumbo for, the informal conversations that a manager or HR has with an employee about whatever their condition is, whatever their limitation is at work, and what sort of accommodation can be provided or might be able to be provided to get that person back to performing, the essential functions of their job. And what it started feeling like in this post is that HR was just kind of checking the boxes, right? They give this person a form, they take it back, and then they're like, okay, we're going to deny this. There might be more to the story, but why? And it seems like it was a little bit too quick, right? Then they say, okay, just try again, right? But at no point here did it sound like there was an actual conversation about what exactly was on this form, what was this doctor saying might work, and then a little bit of back and forth on, okay, oh, we can do this, or maybe we can't do this, but maybe we can try this. And that's the entire point of the ADA accommodation process. It's just a conversation to figure out what works for this person and for the business, and can we implement it. What I was really shocked by was HR saying right off the gate, I know that they are going to deny this. Typically, HR is involved in this accommodation process, but they're usually not the boots on the ground type person who makes the final decision on accommodation that does or doesn't work, because ultimately the accommodation has to be something that actually works for the job. And depending on what this person does, HR may not have like the full day-to-day picture of what is feasible for this job or what's not feasible. So for HR to be kind of telegraphing, I know that they're going to deny this, almost signals an ADA accommodation denial and potentially even retaliation, just by kind of touting their expertise and their experience with this. I know that they're going to deny this because apparently I've been there, done that, and I've seen it all, right? But you don't necessarily know that, and I don't know that we actually know what's going on with this person and what can or cannot get them back to work. So there's really no universe where saying that I know that they're going to deny this is helpful. I think you can say something like, hey, we may need to fix this up a little bit, or can you provide a little bit more detail on this thing, or can you go back to your doctor with this thing, and then let's take it back to the manager to, talk about whether or not something's feasible. And when you do that sort of stuff, you create some sort of liability, because now you're denying accommodations, which is by definition discrimination under the ADA, assuming, of course, that no accommodation was actually available. What makes the story a little bit scarier, or that much scarier for HR and legal teams at Target, is that this is an employee who kind of already knows what this process should look like, right? This employee said, I know they don't have to give me what I asked for, but I was expecting at least something, right? This is an employee who understands that an accommodation, you don't have to get the accommodation of your choice, but you are entitled to an accommodation, some reasonable accommodation, if it exists, right? And so when you're dealing with an employee like this, you have to be a little bit more careful, because they are a little bit more likely to actually bring a claim if they feel like the denial was improper, right? They already have some inclination of what the law does and doesn't require. Listen, we don't know enough from just this post about who was right and who was wrong, right? Maybe there wasn't an accommodation available for this person, or maybe there was. Maybe HR was completely right at the end of the day. I don't know. What I can tell you from real life experience is that when an employee feels like they are getting the short end of the stick, when they feel like they have not been treated fairly in the process, even if you were right in denying that, you are opening yourself up to a risk of a lawsuit, because people who feel like they've been shorted and who feel like they weren't treated fairly will bring a claim. Maybe you win that claim at the end of the day. Happens all the time where employers win the claims, but you still lose at the end of the day because now you have to defend a lawsuit that you might have been able to avoid had you played ball a little bit more. And if you need help with any of this, or if this just sounds familiar to you, click the link below to schedule a consultation with me.